Hi everyone, and welcome back to our VWV Employment Law podcast. My name's Jess. I'm a legal director and knowledge lawyer in the employment team.
And I'm Nick, a partner in the employment team. Today we're focusing on the reforms to non-disclosure agreements, NDAs, under the Employment Rights Bill. These reforms are designed to prevent NDAs being used to silence allegations of harassment, discrimination, or failures to make reasonable adjustments. We'll look at what is changing, how the new rules fit into the wider policy landscape, and the practical implications for employers.
Yeah, and this episode is part of our Workplace Compass series. So Workplace Compass is our dedicated resource that we have created to help employers navigate the employment law changes that are happening at the moment. So if you haven't already, please do like and subscribe to our podcast, because we are going to continue to provide updates throughout the whole process as the Employment Rights Bill moves from Parliament through to implementation. So in terms of what's changing then with NDAs, the bill introduces some really quite significant restrictions on the use of NDAs in an employment context. So once these provisions come into effect, any clause in a contract that prevents a worker from making allegations or disclosures about harassment, discrimination, or failures to make reasonable adjustments are going to be void. And the provisions are going to apply both to employment contracts and also to settlement agreements. So before we dig into the detail of all of this, it's probably just worth a note to remember that, of course, the bill is already amending the whistleblowing framework slightly to confirm that disclosures about sexual harassment will specifically qualify as protected disclosures. And it has, of course, long been the case that employers can't lawfully prevent a worker from making a protected disclosure. So that was already in the bill, and we were all pretty familiar with that. But what we're now seeing is a much broader set of restrictions, because the voiding of the NDA clause will apply regardless of whether the disclosure meets the technical test for whistleblowing protection.
Yeah, and importantly, these NDA provisions also cover disclosures about how an employer has responded to allegations of discrimination or harassment. For example, failing to investigate or retaliating against the worker that's raised the concerns. So the restriction is not limited to the underlying behaviour, but extends to the employer's handling of it as well.
That's right, Nick. But, of course, whilst all that is the case, the provisions don't mean that all NDAs will completely disappear, and that is important to understand as well. So confidentiality clauses that protect commercially sensitive information, so trade secrets or financial data or strategic information, or all of that will remain enforceable. So the voiding mechanism will only apply to clauses that prevent disclosures about discrimination and harassment.
Yeah, and the bill will also introduce a new concept of accepted agreements, with further detail to be set out in future regulations. The government has suggested it may follow the Irish model for these accepted agreements, where confidentiality is still permitted if the worker actively requests it, has had independent legal advice, and benefits from a cooling off period.
And all of this also sits alongside wider developments outside the context of the Employment Rights Bill. So the Victims and Prisoners Act 2024 already makes NDAs unenforceable if they prevent a victim or someone who believes they are a victim from reporting a crime or seeking support. And also, more recently, the government has confirmed it's got plans to go even further in this direction by introducing a new provision under a separate piece of legislation, the Victim and Courts Bill, which would void NDAs that prevent the disclosure of criminal conduct or responses to it to anybody, so not just the specified bodies that are provided for currently.
So there's a lot of change in the pipeline. So in terms of the practical implications for employers, the reforms mean reviewing standard confidentiality provisions with these changes in mind. Standard NDA drafting, especially NDAs that are included in template settlement agreements, will definitely need updating in light of these proposed changes.
Yeah, that's right. And you will probably have seen there's lots of commentary sort of speculating about what the impact of these provisions is going to be on the settlement landscape generally. So are there going to be fewer settlements because of the restrictions on confidentiality protections? And on this, we're not going to know for sure is the answer until the law changes. But there is some sort of anecdotal experience trickling in now from employers in other jurisdictions where there are similar laws already in place. So Ireland and some North American states in particular. And employers in those places are being said to still value the certainty, closure, and of course the control of costs, which all go hand in hand with settling disputes. And by the same token, individuals often want the matter resolved on their own terms under settlement agreements.
Yeah, definitely. And so confidentiality isn't going to disappear entirely, but it's probably going to be continuing to move into a more transparent and defensible space.
Yeah, and that's the starting point anyway. And Nick, before we move on, it's probably also worth mentioning the changes we're also seeing in parts of the public sector where there are already confidentiality restrictions in sector guidance that go much further actually than the Employment Rights Bill. Over the past few months, we have seen various pieces of government guidance place tighter limits on the use of confidentiality clauses, particularly where public money is involved or where transparency duties are higher.
Yeah, that's right. I provide a lot of advice to clients in the education sector, and the education sector is a really good example of this. The Academy Trust Handbook, for example, was updated in October 2025 and now contains some strict expectations around confidentiality clauses in settlement agreements. So Academy Trusts are now required to obtain prior DFE approval before including any confidentiality clause in a settlement agreement where a special severance payment is being made alongside it.
Yeah, and the same direction of travel appears in other parts of the public sector too. So the College Financial Handbook also includes that same requirement for prior DFE approval, and the public sector exit payment guidance requires Treasury approval in the same circumstances.
So for many public sector employers, the reality is that they already operate under restrictions that go further than anything that's set out in the Employment Rights Bill.
Yeah, absolutely. So let's just spend a moment then thinking about what employers can do now. So the government hasn't included the NDA provisions under the Employment Rights Bill within the roadmap, the implementation roadmap for the bill. So that means that we don't yet have a confirmed timetable for when these changes are going to take effect. But that said, it is still a good time to take stock. So I think it's a good idea to review where confidentiality appears in your contracts, your policies, templates, settlement agreements, and internal procedures. And that's a really sensible first step. And what you are probably aiming to do at this point is to map out the areas where you think you might need to make changes once the law changes.
Yeah, and training on this is going to be absolutely crucial. The reforms place a much greater emphasis on how concerns are handled in the first place through investigations, fair outcomes, and processes that stand up to external scrutiny. So giving managers and HR teams the confidence to deal with complaints sensitively and consistently is increasingly a key part of employers' risk management.
Yeah, I think that's right. And reputational resilience depends far more on openness and integrity and on the ability to reflect and learn lessons and make improvements than it does on confidentiality provisions and the extent to which you can rely on those. So organisations that start preparing now by reviewing their documentations, heightening their processes and upskilling their managers, I think are going to be in a much stronger position once the NDA reforms are brought into force.
Yeah, and that brings us to the end of this episode. So thank you very much for joining us as part of our Workplace Compass series.
Yeah, thanks very much indeed. And if you found this episode helpful, please do like and subscribe to the series, because we are going to continue to update you as the Employment Rights Bill continues its progression through Parliament.
And if you'd like more insights like this, take a look at our full Workplace Compass playlist or visit our Employment Rights Hub for further resources.
Thanks very much for listening, and see you next time.